Good morning, everybody. Good morning. Good morning. Welcome to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for The Law of Self-Defense. Thank you very much. This is a quick show I've put together on a moment's notice to play a little catch-up on the Murdaugh murder trial. This is a murder trial taking place out in South Carolina, really brought to my attention by Andrew Esquire last night. He invited me on his show to talk about it a bit, and it looked like it might be interesting enough for me to cover for the Law of Self-Defense community. Andrew said he would send me an invitation link to their coverage of the trial this morning, but he's coordinating with Legal Vices. Both of them are in South Korea. I'm not sure they communicated together about sending me a link. We'll see what happens. If a link comes in, I may switch to covering the trial on their channel. In the meantime, however, I wanted to cover the opening statements from yesterday and do that as quickly as we could. Let's see, do I have it? I thought I had it all set up already. Let me pull that up. In the meantime, I should mention the sponsor of today's show, which is none other than Law of Self-Defense itself. We're doing our Law of Self-Defense advanced class on Saturday, April 15th. Right there. And that's a full day class taught live by me on everything Law of Self-Defense. And if you sign up for that April 15th class this month in January, only a few days left for that, folks, you get 50% off the normal registration. Next month, it'll only be 25% off. You can learn more about that class, what we cover, why you should be there. We only teach this class once, sometimes twice a year, folks. So this is a rare opportunity. Learn more, register at lawofselfdefense.com/advanced. And let's see. Now I just have to find what I did with my streaming of yesterday's trial. Now, the opening statements. I'm told the opening statements were quite brief, and I'm going to play them in an accelerated manner, so probably 1 1/4 speed. Hopefully, we can get through them before court starts this morning, which should be in about half an hour. I have that up. I'll have that up on another screen so I can be aware of when that occurs. Let me rewind this here. That should be right about when the opening statement by the state begins. We'll see the judge for a few seconds, and then the state will run into opening statements. I'll put on the closed captioning. I'll change the speed to 1 1/4. And here we go.
To you. We'll now proceed to opening statements by the state.
Thank you, Your Honor. May it please the court. On the evening of June 7th, 2021, at the defendant's property off Moselle Road in Colleton County, his son, Paul Murdaugh, was standing in a small feed room with some kennels they had on the property. About 8:50 p.m., and the defendant over there, Alec Murdaugh, took a 12-gauge shotgun and shot him in the shoulder, in the chest and the shoulder with buckshot. And the evidence is going to show it was a 1,000,000 to 1 shot. He could have survived that, but after that, another shot went up under his head. It did catastrophic damage to his brain and his head.
I would think so.
The evidence is going to show that Paul collapsed right outside that feed room. And just moments later, he picked up a .300 Blackout, which is a type of ammunition, but an AR-style rifle. And the evidence is going to show that the family had multiple weapons throughout the property. Picked up that .300 Blackout rifle and opened fire on his wife, Maggie, just feet away near some sheds that used to be a hangar. Pow, pow. 2 shots, abdomen in the leg, and took her down. And after that, there were additional shots, including 2 shots to the head that, again, did catastrophic damage. and killed her instantly. The evidence is going to show that neither Paul nor Maggie had any defensive wounds. Neither one of them had any defensive wounds, as if they didn't see a threat coming from their attacker. And the evidence is also going to show that both Maggie and Paul were shot at extremely close range. The evidence is going to show it's called stippling. It's almost like a tattoo, that when you get shot very close to a weapon, it leaves marks that the forensic pathologist can see. They were shot at close range and they did not have defensive wounds. And the evidence is going to show that the defendant, Alec Murdaugh over there, told anyone who would listen that he was never at those kennels. But the evidence is also going to show from these things that every one of us, most of us carry around in our pockets, that he was there. And he was there just minutes before, with Maggie and Paul, just minutes before their cell phones go silent forever and ever. Despite what he told people, I was never at those kennels, the cell phones are going to show otherwise. Ladies and gentlemen, my name is Craig Waters. I'm with the Attorney General's office, and I'll be the lead prosecutor. I introduced myself before. With me is David Fernandez, Savannah Gow, John Metters, Don Zelinka, John Conrad, and Johnny James. A lot of lawyers. This is a big case. It's a very complicated case, and that's why there's so many people working on it. Sitting back in the row, we have David Owen, who's the lead investigator. We have Lieutenant Charles Gint, who's one of the agents, Special Agent Ryan Kelly, and Special Agent Peter Rudolph. Some of the agents that are working on the case, as well as Investigator Isaac Toledo, who's working on the case as well. There's some of the witnesses that you'll hear from as we go through this case. The judge talked to you a little bit about him being the judge of the law, and he gives you the law. And I'm going to talk a little bit about some of the legal concepts before I turn back to those facts. Just remember, though, he's the judge of the law, so you take what he says, but I'm going to explain to you some of the legal issues from my perspective before we talk a little bit more about the evidence in the case. And the first thing is, right before you went to lunch, y'all all took an oath. Everybody in this courtroom who's got involvement in this case takes an oath. You know, attorneys take an oath to become an attorney, take another oath to become a prosecutor, judge takes another oath to become a judge, witnesses take an oath on the stands, law enforcement take oaths to become law enforcement, but y'all took an oath as well. And the reason why is that y'all have the most important job in this courtroom. Every one of you raised your hand and said that you would well and truly try this case. And it's the most important job here, because like the judge said, he's the judge of the law, but y'all are the judge of the facts. Y'all are going to listen to what comes from that witness stand and judge those facts. But you also have to be mindful of that oath. That oath requires you to do that hard job, to make that decision, to call the strike when you see it. It's the same oath. It's just as important as any other oath. This might be the most important in this courtroom. The judge mentioned reasonable doubt, and he's exactly right. It's the state's burden to prove this case beyond a reasonable doubt. That is a cornerstone of our country. I wouldn't have it any other way. It's a burden we welcome. It's what we want. It's a system that has been well tested and true, and we take that burden to prove the case beyond a reasonable doubt. And I want to remind everyone that the emphasis is on reasonable. Okay, it's not any doubt; it is reasonable doubt. Reasonable doubt is often defined. Again, listen to the judge how he defines it. But reasonable doubt is a doubt that will cause a reasonable person to hesitate to act. And when you hear the evidence coming from this stand about this particular case, I submit to you, you won't hesitate to act. Again, remember the emphasis is on reasonable doubt. The judge mentioned the charges, and there are 4 of them. First indictment accuses Alec Murdaugh, to which he's pled not guilty, but it accuses him of murdering Maggie Murdaugh. The second indictment accuses him of murdering Paul Murdaugh. The third indictment accuses him of possessing a firearm during the commission of a violent crime, that being the murder of Maggie Murdaugh. And the last one accuses him of possessing a firearm during the commission of a violent crime, and that being the murder of Paul Murdaugh. And what does that mean? What is murder? Well, the judge again is going to instruct you that it is the unlawful killing of another with malice aforethought. And what is malice? Malice is a mental state. That's ultimately going to be for y'all to determine as to what was going through Alec Murdaugh's mind when he committed these crimes. What is malice? Malice has often been defined as the intentional doing of a wrongful act without just cause or excuse. It is the intent to inflict an injury under circumstances that the law would presume an evil intent. An evil intent. And when you look at the circumstances of the crime, and you look at what led up to this crime, the evidence is going to show that there was malice aforethought. Aforethought, what does that mean? It means it has to exist at the moment you commit that crime. It doesn't have to be planned. It doesn't have to be planned for any long period of time. It just has to exist a split second before the crime is committed. But when you see this crime and you hear all the circumstances, the evidence is going to show that before it existed for a while. It existed for a while in the mind of Alec Murdaugh. You're also going to hear about circumstantial evidence. And a lot of times people hear, oh, it's just a circumstantial case. But the law says otherwise. The law says that circumstantial evidence is just as good as direct evidence. And what's the difference between the two? Direct evidence is supposedly about the storm out here, from what I'm told. Direct evidence is if it's sunny outside and a witness goes outside and it's sunny and they come in here and they get on my witness stand and because they saw it raining, they sit on the stand and said, I was just outside and I saw it rain. I saw it raining. That's direct evidence. They actually saw it rain. But to give you an example of what circumstantial evidence is if the witness goes into a room where all curtains are drawn. And when they go into that room, it's sunny outside and everything's dry. And while they're in that room, they see it darken behind the shades. They hear thunder. They hear the wind blowing. They hear the sound of raindrops on the roof. And then they open up the door, and it's not raining, but everything is wet. There's puddles in the driveway. There's puddles in the street. There's puddles in the yard. There's limbs down all over the ground. And then they come in here and say, yeah, it was raining. Didn't actually see it raining, but those circumstances are beyond any reasonable doubt that it was actually raining. Now, I guess it's possible that somebody could have been standing outside the window and beating the drum to sound like thunder and blowing a fan to make it seem like it was the wind and somehow got enough water to coat the entire neighborhood. But that's not reasonable. Everybody understand that distinction? That's not reasonable. Another thing, and this is crucial, what you're going to do in this particular case, is determine credibility or the believability of witnesses. So it'll be your job to look at the evidence, the exhibits in the case, but also the witnesses and decide if it's truthful, if you believe it, if you can rely on it. And the judge is going to instruct you that you can believe one witness against many or many witnesses against one. You can believe all the witnesses' testimony or part of the witnesses' testimony. It's up to you, first individually and then as a product of your deliberations. And what you're required to do there is just rely on that good old-fashioned common sense. Does it all fit together? Is it corroborated? Does it fit with what you would expect? Does it fit with what you expect how real people would act? Does it seem real? Or does something seem a little off? Does something seem a little off? You're going to see video statements of Alec Murdaugh. You're going to see body-worn camera of him at the scene when law enforcement arrives. And hear what he says. And hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progress about what he says and what he says he did that night. Watch those closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right? Or does something seem a little off? Something seems a little off. I mentioned that Maggie was killed with a .300 blackout rifle, an AR-style rifle that chambered in .300 blackout ammunition. And you're going to hear evidence that back in Christmas of 2016, Alec Murdaugh over there bought 2 .300 blackout AR-style rifles. And then not long after that, one of them went missing from Paul's truck. And time went by, and in April of 2018, Alec Murdaugh replaced that rifle and bought another one. 3 total blackout rifles that they had. One of them went missing years ago, and a replacement was bought. You're going to hear evidence that Paul and his friend were using that replacement gun. They were standing right outside the side door to the gun room of the house, and they were sighting it in, firing down into a field. And the cases were ejecting. The cases are the empty shell from a bullet, and they were ejecting out into the flower bed right there. And then there's a range across the street, and they shot it there, and there's cases ejected there as well. And they were shooting that 3rd replacement gun just weeks prior to the murders, prior to June 7th, 2021, when Maggie and Paul were murdered. And you're going to hear forensic evidence that the cases that were found in that flower bed and the cases that were found across the street at that range were ejected out of the same weapon that fired all the cases that were around Maggie's dead body, that killed her. It was a family weapon that killed Maggie Murdaugh. And you're going to hear evidence that of those 3 blackouts that Alec Murdaugh purchased, when law enforcement arrives at the scene on June 7th, 2021, he can only account for one of them. He can only account for one of them. And that replacement gun is nowhere to be found. You're also going to hear evidence that the type of ammunition, the exact brand, the exact model of ammunition that was used to kill Maggie, S&B, 300 blackout ammunition, and 147 grain bullets, that exact ammunition, boxes, empty boxes of that ammunition, is found all over the property. The very same brand and model of ammunition that was used to kill her is found at multiple locations throughout the property. And you're also going to hear evidence, the same thing about the shotgun shells that killed Paul. Federal double-aught buckshot unfired rounds were found on the property, as well as Winchester #2 turkey legs, the 2 rounds in the shotgun that killed one. Family weapon, same ammunition on the property. You're also going to hear evidence that about a week after the murders, Mr. Al Murdaugh's father had died, Mr. Randolph, and about a week after the murders, he shows up early in the morning at his parents' home, where his mother still is in late-stage Alzheimer's, on Alameda in Hampton. It's uncharacteristic for him to show up early, uncharacteristic for him to show up at all like that. And he comes in, and he's carrying something in a blue tarp, and he takes it upstairs. And eventually law enforcement finds out about that. And they go upstairs, and they find a wadded up, very, very large raincoat in a blue color. It looked like a tarp. And you're going to hear evidence that it was coated with gunshot residue on the inside. On the inside. You're going to hear other evidence of gunshot residue. You're going to hear that there was gunshot residue on Alec at the scene. You're going to hear the evidence that there was gunshot residue on the seatbelt of the car he was driving. You're going to hear evidence that when law enforcement got to the scene, he had gone and gotten a shotgun, Paul's shotgun, and that Maggie's DNA was on that shotgun. You're going to hear other evidence from DNA, gunshot residue, firearms examiners. There's going to be a lot of forensic evidence in this case. And I'm not going to get into every single bit of it right now, but I will say that a key piece of forensic evidence that you're going to hear in this case is the cell phone evidence. Alec's cell phone, Maggie's cell phone, Paul's cell phone. You know, this is all amazing technology that most of us carry around in our pockets. It really allows us to do a lot of things and to get a lot done. But this cell phone keeps track of who we're talking to.
This is the prosecutor.
Who we're calling, who we're texting, whenever we access apps. And every time you do that, there's a record kept in this phone unless it's deleted somehow. If you're using certain apps, you can even get GPS information where you were when you did that that's stored on these phones. You're going to hear evidence about that. You're going to hear evidence that when you make a call and it pings off the cell towers, the location information can be gathered from that as well. And so it allows an investigation to take this and piece together what someone was doing on a particular day, and not only what they were doing, but who they were interacting with and how they were interacting with them. This is going to be crucial evidence for you to consider. You're going to hear that particularly Alec and Paul, but also Maggie, were prolific cell phone users, to the point where Paul's friends even had a nickname for him about his cell phone usage. Before I talk more about that, there's 3 family properties I need to talk about. Okay, the first one I've mentioned is Moselle. Moselle in Colleton County. It's called Moselle. It's off of Moselle Road, but everybody refers to it as Moselle. And that property is large. It's a lot of acres. There's a main house on it, and there's a driveway that goes to that main house. But it used to be an airstrip, and there's an airstrip that goes down, and then down the way, just less than a third of a mile away, just a 3-minute walk, 4-minute walk, 45-second drive, is the kennels and the shed that used to be a hangar where Paul and Maggie were murdered. So the main house is just less than a third of a mile away. You can see the kennels from the main house. You can see the main house from the kennels. The family also had a house in Edisto at the beach. And the evidence is going to show that that is where Maggie preferred to stay, particularly in the summer months. She liked the beach. She was not a hunter. She didn't want to be at Moselle. She didn't want to be at the lodge where it was hot and buggy. She liked being in Edisto. And then there also, I've already mentioned, the house in Alameda, which is where his parents' home. On June 7th, 2021, you're going to hear evidence that his father went into the hospital and the prognosis was not good. And in fact, he died a few days later. And his mother is in late-stage Alzheimer's, and that house being cared for by a caretaker. You're going to hear from that caretaker.
Mr. Waters, yes, sir. We pause for a moment. We'll be at ease for just a moment.
Yes, sir, Your Honor.
Well, it's a good opening. Everyone's standing up. Jury being excused. It's odd in the middle of opening statement. The real risk for the danger for the defense here is that the jury will actually not go by a beyond a reasonable doubt standard, despite how they're instructed, but they'll go by a preponderance of the evidence standard. That's how most of us make decisions. Do we think it's more likely than not that we should have a hamburger for lunch as opposed to a hot dog for lunch? We don't normally make decisions beyond a reasonable doubt. Only in the most important affairs of our life, as a common beyond a reasonable doubt jury instruction goes. The state is stitching together an interesting story here that seems consistent with the facts. Is it proof beyond a reasonable doubt that he murdered his wife and son? You know, a lot of people get convicted actually on a preponderance standard. The jury concludes, I believe it. I believe the state's narrative of guilt. And they may believe it strongly, 60, 70, 80%. That's well over preponderance. So they really think it's more likely than not the defendant murdered these people. Is it beyond a reasonable doubt? Not really, but is it enough to convince a jury to vote guilty on a verdict form? Often, very often. So if I were the defense, I would be pounding the heck out of that beyond a reasonable doubt standard. Folks, I'd be happy to be on Nick's show. I sent him a message, but he'd have to invite me on, you know. So no reason he wouldn't, but it's I guess, you know, it's not like we've had a falling out or anything, but it's you know, it's that's Nick's show. So I certainly wouldn't take offense if he decided to cover the trial on his own. It's entirely up to him. If he does, I perhaps I'll continue covering it myself. We'll see. And I had also talked with Legal Mindset yesterday. And the judge is back. I wonder what that was all about. All right. Bathroom break?
You may proceed.
Thank you, Ron. All right, we were talking about the three family properties. Moselle has the main house and the kennels / sheds. The main house has a driveway, but the kennels also have a driveway. And the evidence is going to show that that was actually as commonly used as the main driveway. In fact, the mailbox is by the kennel driveway. Driving right past those kennels were Paul and Maggie were murdered. I told you that you're going to hear evidence that Maggie did not like being in Moselle as much as she liked Eddystone, the beach house. But that, on June 7th, 2021, she came back to Moselle. And the evidence is going to show that she arrived about 8:15. And the evidence is going to show that from the cell phones that Paul was there at the house, the main house. And Alec Murdaugh himself says that they ate dinner. And the autopsy is going to reflect both Paul and Maggie having similar stomach contents, indicating that they recently shared a meal together. About 8:30, about 15 minutes after they arrived, Paul's phone starts moving towards the kennels. You're going to hear evidence again that the defendant said he was never at those kennels, that he was napping after they ate, and he was at the main house and never went there. You're also going to hear evidence about how much Alec used his own cell phone, and it would be unusual for him to be anywhere without a cell phone. At 8:44 and 55 seconds, Paul recorded a video. He was down at the kennels because he had been talking to a friend of his. And you're going to hear from this friend because his friend's dog was in the kennels and they thought there was something wrong with the tail. And Paul was recording a video of it to send to his friend. 8:44 and 55 seconds. And on that video, and you'll see that video, and you'll hear from witnesses that identify Paul's voice, Maggie's voice, and Alec's voice. Told anyone who would listen he was never there. At 8:44 and 55 seconds, there's a video. The evidence will show that he was there. He was at the murder scene with the two victims. And more than that, just over 3 minutes later, 8:49 and 1 second, Paul's phone locks forever. He never reads another text. He never sends another text. He doesn't answer calls. 3 minutes after that video has the defendant at the murder scene with the two victims, Paul's flip phone goes silent forever. And in fact, another communication comes into the very friend that he was talking to the dog at 8:49 and 35 seconds, just 35 seconds later, and he doesn't answer. He never answers another thing forever now. And on top of that, Maggie's phone locks at 8:49 and 31 seconds, around that same time, and she never answers another text, never sends another text, never makes another phone call, never receives another phone call. 3 minutes, ladies and gentlemen. 3 minutes after a video shows he's at the scene with the victims, and he told everybody he was never there.
That's bad.
Credibility, ladies and gentlemen. Credibility. So what happens after that? Well, you'll hear evidence that Alex's phone was conspicuously, he didn't have a lot of activity from about 8:09 p.m. until 9:02 p.m. And if he was at the kennels, which the evidence will show, why is his phone not with him? Why is it not showing activity? But you will hear that at 9:02, all of a sudden his phone does start to pick up activity. At 9:02, he calls, he starts moving. At 9:04, he calls Maggie's phone. Doesn't answer, of course. Doesn't answer. He calls his father, Randolph, who's in the hospital. Doesn't appear there's an answer there. He calls Maggie again at 9:06. Remember, he's just a third of a mile away. You can see it. At 9:06, she doesn't answer. At 9:06, he turns on his car, the Suburban, and he texts Maggie that he's going, be right back. I'm going to go check on Mom. And he doesn't drive down to the kennels, even though that's where the mailbox is. That's a common place to be, even though you can see it. He's called his wife 2 times and texted her, and she hasn't responded. But he doesn't just drive down there and say, hey, I'm heading. You guys want to go? What's up? What's up? Right there. You can see it. He then drives to Alameda, where his mom is suffering from Alzheimer's, and the caretaker is there. And he starts calling people. He's talking to people. It'll be up to you to decide whether or not he's trying to manufacture an alibi. He comes, he gets there to Alameda. You'll hear evidence about whether or not that was usual. You'll hear evidence about how he was acting when he got there. And he's only there for 20 minutes because he's back underway at 9:44. And he makes more phone calls on the way back. Calling friends, calling people who will answer. It'll be up to you to decide whether he's trying to create an alibi. And he gets back to Moselle at 10:01. And he calls 911 at 10:06. Listen to that 911 call. Listen to what he says. Listen to what explanations he may offer. You're going to hear that 911 call, but you're also going to see the body-worn camera of the officers who arrived at the scene. The video camera they wear, so that it records what they're doing. And you're going to see what he did to Maggie and Paul. It's going to be gruesome. There's no other way around it. It's what he did. You're going to see crime scene photographs. You're going to see the traumatic injuries that were suffered. You're going to hear from a pathologist, a doctor who will examine the injuries. It's going to be gruesome. No other way around it. On that 911 call and on the body-worn cameras, pay attention to what he says. Look at how he's acting. But he says within a few minutes of each one of those, he says, this is about the boat case. This is about the boat case. And you're going to hear some of what was going on in Alex Murdaugh's life leading up to that day. Stuff that happened that very day, stuff that was leading up, a perfect storm that was gathering, much like the storms that are coming outside today. Listen for that evidence. Listen to that gathering storm that all came to a head on June 7th, 2021, the day the evidence will show he killed Maggie and Paul. This has been a long, exhaustive investigation. It's going to be a fairly long trial because it's complicated. It's a journey. There's a lot of aspects to this case. There's a lot of factors to this case. But like a lot of things that are complicated, when you start to put them all together, piece them together like a puzzle, all of a sudden the picture emerges and it's really simple. It's really simple. once we get to the end of that journey, and you have a chance to deliberate, the evidence is going to be such that you're going to reach the inescapable conclusion that Alec murdered Maggie and Paul, that he was the storm, that the storm was coming for them, and the storm arrived on June 7th, 2021, just like the storms that are heading here right now, that they died as a result, beyond any reasonable doubt. Thank you.
All right, so that was the state's opening statement. It's a circumstantial evidence case. He's knit together a pretty good narrative of why the jury ought to ultimately conclude that this defendant, Alex Murdaugh, killed his wife Maggie and his son Paul. It's the real danger here for the defense is well, frankly, one of them is going to be this guy's appearance. I mean, he looks like he was cast in Hollywood as the bad guy in a movie. It shouldn't matter, right? But it doesn't help. And that the jury will ultimately decide this on simply a preponderance evidence, whether they, in their gut, believe it's true that he killed his wife and son. Now, we've only heard one side of the story so far. I will say that the courtroom is, people are in the courtroom now this morning. So I may, let's see, switch screens here. Whoops. Didn't have to do that. This is the view from the courtroom right now. The family has come in. The Murdaugh, looks like the Murdaugh family. It looks like maybe another son of his. Certainly looks like the defendant. And the state here did a really good job laying out the legal doctrines, providing the jury with a path to convict on an entirely circumstantial evidence case. It's going to be important, this circumstantial evidence, how compelling we find it. Really important is going to be the testimony, the evidence about the demeanor of this defendant, especially in the immediate aftermath of these killings. The demeanor as described by witnesses, the demeanor as captured on body-worn camera, and devastating to the defense will be the defendant getting caught in any apparent lies. Because if you can't believe the defendant in what he's saying, there goes the entire defense. So if he said things like, I was never there, and there's compelling circumstantial evidence that he was there. Now, again, we've only heard the state's side of the evidence so far. So you hear one side of an argument, it always sounds compelling. But if there's compelling circumstantial evidence that he said he wasn't present where the killings occurred, and in fact, his phone says he was there, he was physically captured on a video that his son was taken, that shows, in fact, that suggests circumstantially that he was there, and you've caught him in a lie, that kind of substantive lie, that's going to make it very, very easy for the jury in this trial to convict. So we'll have to see. Doesn't look like anything. I am live on the courtroom feed. Let me see what else is going on. So quick overview of the case. He's accused of murdering his wife and his son, an adult son, shooting the son with a shotgun, a buckshot to the chest and shoulder, and it sounds like a turkey shot, number 2 turkey shot to the head, as the absolutely fatal injury. Frankly, it's shocking that the buckshot to the arm and shoulder didn't completely take him out. Shotguns take body parts off of people, folks. Their injuries are typically extremely devastating, and particularly with buckshot, as the first shot is indicated here by the prosecution. It's a little odd that he would change to birdshot, but sometimes people mix shells in the magazine, typically the tube, most commonly of a shotgun. Then the 300 blackout rifle was used to kill the wife. 300 blackout typically fired in an AR style rifle. Rifles are usually the most common, by far the most common caliber are 5.56 millimeter, 5.56 or .223 caliber. They're not identical rounds, but they can typically be fired out of the same gun. They're sufficiently similar rounds for that purpose. The 5.56 is a higher pressure round for a variety of reasons, usually in a military context, to help ensure proper operation of weapons. But they can typically be fired out of the same gun. The 223 5.56 round is, well, the bullet is 0.223 in diameter, so less than a quarter of an inch in diameter, smaller than a pencil, a number 2 pencil in diameter. Very high velocity round, 3,000 plus feet per second. It's the kinetic energy that really causes the most damage, especially if the bullet yaws in terminal ballistic manner when it hits the target. The 300 blackout is a much fatter 0.3 instead of 0.223. 0.3 caliber round, 0.3 of an inch, a big, fat, heavy round. The case is very similar to the case of the 223 5.56 round, so they can be loaded in the same magazine, and they can be fired out of a similar platform. Now, the chamber for the two rounds, 300 and 223, is obviously very different. It has to fit a much larger bullet. The chamber and the rifle will be different. It's not uncommon to see video of people who've accidentally loaded a 300 round into a magazine they think is all 223. And then they feed that 300 round into the 223 gun and blow the gun up. Because, of course, the 300 round cannot, in fact, chamber correctly in the gun. So it's not fully seated in the chamber, gets discharged, and the AR will just come apart violently, disassemble itself when someone manages to detonate a 300 blackout round in a 223 caliber AR platform. The nice thing about the 300 is you can have the rounds be subsonic. I mentioned that the 223 5.56 rounds are very fast, 3,000 plus feet per second, supersonic. So you get a sharp crack when the bullet travels through the air, even independent of the sound of the gun firing. It's quite loud. A 300 can be subsonic, meaning it's traveling, the bullet when fired travels less than the speed of sound. So you don't get that sonic boom effect when the bullet travels through the air. And you can suppress the sound of the gun being fired with a suppressor on the end of the barrel, of course. And you end up with a pretty quiet shooting rifle that's firing a big, fat, heavy round. For those reasons, 300 blackout is becoming somewhat favored for things like home defense. You have a big gun, a lot of rounds in the gun for dealing with a lot of bad guys if you have a home invasion kind of situation, but you can suppress the gun so that you don't deafen everybody in the home. All right, so the judge is here.
Good morning.
We'll start, of course. They should start with their strongest witness. That's what I would do.
An email was sent to my chambers at 5:52 p.m. yesterday by someone by the name of Chris Wilson, who I don't know whether it's the Chris Wilson who's on the witness list or not, complaining about the violation of my court order prohibiting the disclosure of the identity of jurors. Did not respond to the email, and I'll make the email part of the record in the case. If counsel can look at it if you like.
Okay, well, that's a little unusual. Judge is doing the right thing, of course, by informing the parties of this ex parte communication from somebody who may be a witness in the case. I'm not sure who he's supposed to be a witness for. And I guess somebody must have revealed some names of the jurors. The judge is suggesting that's what this Chris Wilson email is complaining about. These lawyers don't know what to do about this either. Like, what do you want to do? I don't know. Should we talk to them about it? Hey, yeah, guys, if you're watching on YouTube, if you could hit like, that would be appreciated. Hit the like, thumbs up, subscribe, of course, if you want to comment. If you'd like to pose questions, as always, on YouTube, they need to be super chats, $5 minimum. If you're watching in the Law of Self-Defense member dashboard, if I should open that up myself. Really decided to cover all this at the very last moment. Oh, come on. Making me log into my own website. Of course, I don't know my security. I don't know my password. We're streaming on YouTube. You can watch it there. We should be streaming on Rumble.
Court reporter has a court's exhibit.
Let's see.
Court's exhibit number 2.
Court's exhibit.
No, I don't need it. You can keep it. Any comment by the state or the defense?
No, Your Honor, none from Mr. Murdaugh.
None from the state, Your Honor.
No.
Yeah. Well, it looks like the Rumble stream's not working. Sorry, folks, if you're trying to watch on Rumble. It is working on the Law of Self-Defense member
Anything
dashboard.
before the jury comes.
Nothing from the state, Your Honor.
Your Honor, the video he's about to show has, I believe he agrees, images which are under the order signed by you. And so as they're being proposed to be shown, if I have something or he has something, we're going to, obviously under that order, we have to disclose that to you. And if you approve the showing, we've got some logistical issues. If you give me just a minute, these monitors are, that one is not working, but this monitor is viewable from the audience, and we'd like to cover it up with some MacGyver-like device that's been developed by Mr. Waters, where you tape paper, we can flip back and forth. So if somebody has some tape, I'd like to do that before we begin so that nothing's shown back there. And you got paper too? I'm sorry.
All right. All right, folks, listen, I'm going to, I have a link from, Nick. So I'm going to hop over to Nick's stream while the court's getting its day together here. I'm going to wrap up my Law of Self-Defense stream. No sense me streaming to my relatively modest audience when I can join Nick instead. So I'm going to hop over and do that. Wrap up the show for today. Remember, folks, if you carry a gun so you're hard to kill, know the law so you're hard to convict. And I'll be covering this over at as a guest on Nick's Recital Law channel. It's either, I'm not sure where he's streaming, but Rumble or YouTube. You know where to look. You know where to find Nick for sure. All right, folks, I will wrap up right now, and I'll see you over on Nick's channel. Stay safe.